sound. That's fine too. Why do we need sound? Sound is optional. How's everyone doing today? Everyone having a good day? We had tech issues, can you tell? Welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we are dealing with tech issues, and we also have a couple cases that we will be dealing with to respond to. So we've got a new complaint from Toddy Westbrook in Nevada regarding her business enterprises. I've been told that this is a whole lot of fun and stuff like that. And then we've got an opinion from the Western District Court of Appeals dealing with Geico and some lady getting an STD by having sex with someone in the car, and Geico has to pay like $5 million in damages. So we're going to cover that. We got an article dealing with a judge from blocking Texas from investigating families of transgender children for abuse. And we got a short one dealing with an Auburn man who has been arrested and found guilty for laying flowers on the grave of his fiancée, guilty of littering. Fun times. So in case you're wondering what the problems were, well, there were several. But most notably, I was trying to figure out how to get the background to also focus while I'm also in focus at the same time. So I was screwing with depth of field because, as you can see, or maybe you said, we got a new addition to the background. It's a Lady Justice with the scales. She is kind of blurry right now, which is not ideal. And also, I got one of those cool little digital counters that Legal Bytes has and Emily D. Baker has for counting down their subs, because I don't know, this seems a little bit like, I don't know, this solution, while free, is a little, I don't know, low rent or something. So I tried to get one of the boxes that Emily D. Baker uses and Legal Bytes uses, but I can't seem to get it in focus while I'm also in focus at the same time. So I tried playing with depth of field and a whole bunch of stuff, and it didn't work. Can't be done? I don't know. I think if you screw at depth of field, maybe you can. It's just a depth of field. How do I get the background in focus at the same time the forefront's in focus? Oh, geez, like people haven't been dealing with that problem forever. Lord. Anyways, let's go ahead and get through these articles. Emily D. Baker and Legal Bytes, by the way, seem to do fine. I just like to note their counters seem to be in focus as they also are in focus. So you say it can't be done, go watch their streams. They seem to have it done. So I do have the counter and it is plugged in, but right now it's so low focus, it's like low rent. Should we just put it in shot anyway to show you my woes? Let's put it in shot anyway so you can do me my shows. Deal with my woes. See, now it's a blurry piece of mess. Doesn't really work. First world problems, yes. Most of the tech problems I deal with are first world problems as you try to get the camera and mic and lighting to work. Yes, they are in fact first world problems. Thank you for that intelligent commentary. Stephanie says WTF. Just talking to the people, Stephanie. You need it closer behind you, so I need to move where it is relative to me. Or I need to change where the camera is or something. Let's see if Stephanie wants to say something else. What camera do I have? I have a Sony Alpha 5100. Yeah. So yeah, we'll figure it out. We'll figure it out. All right, let's go ahead and deal with these let's deal with these articles. Hope everyone's having a great day. All right. And I should take this off for the purposes of filming. In case you're wondering, sometimes my wrist gets a little sore. So I put it on so it isn't as sore, because it helps keep it in place. Just a simple, wrist stabilizer. Nothing fancy, but it's not really great for the imagery. All right. For today's story, we deal with a situation in which an Auburn man has been arrested and convicted for laying flowers at the grave of his fiancée. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. I am not in the mood for jokes. For today's story, we are dealing with a situation in which an Auburn man wants to leave graves. Apologize, let's try that again. The Supreme Court did not rule that First Amendment suits are not allowed in federal courts. Try harder. Good morning, chill out. Thank you for telling me how to feel. I appreciate that you are in fact the regulator of my emotions. Do I have your permission to feel angry or upset? Please let me know. For today's situation, we are dealing with a man who wanted to lay flowers at the grave of his beloved, his fiancée. However, the fiancé's family had some problems with him, and so said, you can't lay flowers at the grave, but he did so anyway. So he was recently arrested and convicted for littering by leaving flowers at the grave of his fiancée. So let's get started with this. I tried increasing the F number, by the way. I increased it so much, it just got really, really dark. I mean, even with lighting on and everything, it just got so dark. Even with lighting in front of me, it just became so dark. And it was still blurry. So I did some stuff. And it didn't work. We'll keep trying. The arrest warrant for Winston Higgins had been charged for littering after he left a flower box on his fiance's grave. Earlier today, the judge heard from both sides if a flower box should be considered litter or not. Dun, dun, dun. In court during a bench trial, Judge Jim McLaughlin found Higgins guilty of criminal littering after leaving flowers on his fiance's grave, with a $50 charge for littering and a court fine of $250. The defense plans to appeal the decision. However, the city prosecutor said there would be no jail time if Higgins agreed not to place any more boxes on the grave. So yeah, not so much with leaving the flowers in a box or something on the grave. That is not welcomed here. Winston, who also is known as Winchester Higgins, lost his fiancée, Hannah Ford, in a car crash in January 2021. She died 1 month after Higgins proposed. That's rough. And now he'd like to remember her because, you know, he was planning on marrying her and stuff. Hagen said that Hannah did not like cutting flowers from a forest. She preferred living flowers. So she's trying to honor that. You know, I'm trying to honor what she liked. She liked the living flowers. So I bring them and put them on the grave in still a living state. Higgins handmade the flower box with real flowers and pictures of them together to be left on her grave at the Auburn Memorial Park Cemetery. This is where things get fun and complicated. This did not go over well with Hannah's father, Dr. Tom Ford, who signed a warrant against Higgins and only got him arrested for littering. Holy shit. Yeah, so this is one interesting little familial dispute over here that we've got going on. The father of the dead woman apparently has problems with the fiancée to the point that he's the one swearing out an arrest warrant against the fiancée for the leaving of the flowers. No love lost here in this family. Wow. Continuing on. Ford says his brother-in-law, Cliff Knight, was the original owner of the gravesite. However, after a fourth box out of the 9 was placed without permission, Dr. Ford took ownership of the plot site and discarded one box after another. Higgins said that Hannah's father never approved of the relationship, you don't say. And today he verbally admitted it when testifying in court. When asked by Higgins' attorney if Dr. Ford ever approved of his daughter dating the defendant, Dr. Ford answered, "No, I did not approve." The bitterness goes beyond the grave, my friends. The bitterness goes beyond the grave. Higgins admitted he asked the city for permission to place the box on the grave and told it would be okay unless the family objected. However, he didn't expect to go to jail over it. According to Auburn Park and Rec, setters, urns, boxes, shells, toys, and other similar items may not be placed or maintained on any lot or grave. Exciting. Sarah Card, an administrator assistant with Auburn Parks and Rec, said she informed Higgins over the phone to stop replacing the boxes thrown away on the grave. Higgins was told if he did not stop, there would be legal action that could lead to arrest. However, she said Higgins did not care and would continue to make the boxes in honor of his fiancée. There is a lot of drama going on here in the Higgins-Ford relationship. Wow. According to documents, Higgins was pulled over January the 4th for an expired tag. Officers ran his tag, only to come back with a warrant that was out there by Dr. Tom Ford. Wow. So this guy's pulled over for a routine traffic stop, and they run his name, and it turns out that he has an outstanding arrest warrant signed by his fiance's father for leaving flowers at the grave of his beloved. A relationship the father never approved of. The hatred runs deep, my friends. It runs deep and wide. Wow. Later, Hagen's attorney, Jeff Tiskell, asked the judge to dismiss the case. He said there was missing information and confusion in the complaint, saying flowers were not considered litter, one would think. Judge McLaughlin denied the request, stating the flower box was a foreign substance that did not belong. Judge McLaughlin directed him to pay the $50 charge for littering and a court fine of $250. Higgins will not be sentenced to jail, but was told he will be if he places more flower boxes on the fiancé's grave. Wow. After the judge told Higgins to honor his fiancée in another way, he gave his condolences to Hannah's father and to Higgins. There was no comment from Tom Ford on the situation, who has a bug up his ass. The city prosecutor did not comment either, as the case is under appeal. Higgins plans to appeal, which he has 14 days to be finalized. Higgins wants everyone to know he supports the community. He appreciates the support. Man, this sounds like a Romeo and Juliet situation, but at least in Romeo and Juliet, the parents learned the lessons after they died. Let's wrap this story up. So, my friends, that brings us let's try that again. So, my friends, that brings us to the end of the story about the Auburn man arrested for leaving flowers on a fiance's grave, which sounds very nice to me. I mean, you know, she died a month after the proposal. You know, young people in love, And he seems like he really cares, and he's gone to the trouble of at least 9 separate times leaving flowers on the grave, which I'm going to bet is more times than Dr. Ford has, if I'm just a betting man. But in any case, he's being arrested, charged, convicted for littering, for leaving the flowers. So, yeah, there's some interesting stuff going on here in Auburn, Alabama, but at least for the moment, that brings us end of discussion of this case. All right. Let's do this Texas transgender one. Yeah, is there any point to having the box there in the shop when it's so blurry? I mean, you can't even see what it says. Didn't really work out, man. Should probably just move it out of the shot again. Kind of looks like shit. Are you losing weight? Damn, I'm trying to, man. I'm trying to. What do you guys think? Is it working for you on any level? For today's story, we cover more about the Texas law that would investigate families of transgender children for child abuse and a judge who has blocked further enforcement of this law. The lights are already up at maximum, so I don't know about that. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we are covering the story of Texas, which recently tried to pass an executive order directing the Family and Protective Services to investigate parents relating to transgender surgeries and transgender transitioning. This, of course, was deeply controversial, and lawsuits immediately ensued. There were a whole bunch of lawsuits, in fact, and so far efforts to enforce this have so far gone blocked. Today we're going to read one article that is the latest of these series relating to this Texas law and the problems going to enforce it, so let's get started with this. Your counter's in focus at my end? Really? You can see that? The Texas Department of Family and Protective Services has said it has opened 9 investigations into families of transgender youth. A Texas judge issued a temporary restraining order on Friday blocking the state from probing families of transgender children who have received gender-affirming treatment the state has characterized as child abuse. So, for whatever it's worth, and we've covered the exact executive order before, this was only trying to get to parents who were going through treatments. That wasn't to say like preventing kids from coming out or things like that. It was only meant to or the way it was written, at least to my eye, was meant to deal with these treatments, many of which are irreversible in some situations. So that was the rule that was put in place. But of course, there's still issues that have to be adjudicated in court. 1999 from Faulkner, off topic, but I'm stuck trying to figure this out. But the Supreme Court ruled that police don't have a duty to protect. Correct. Are court order protection orders actually enforceable? No. That is Castle Rock versus Gonzalez, and it's Winnebago versus DeShawney. I like easy ones I can answer. Judge Jane Soffer ruling stops investigations of 3 families who filed the lawsuits and prohibits similar investigations against members of the LGBTQ plus advocacy group, the PFLAG. What I really wanted to say there was the LGBTQ plus ampersand tilde, accent aigu, WPXY coalition, but I decided not to because I thought that, maybe that would be a bad plan. Maybe another time. I do feel there is sufficient reason to believe the plaintiffs will suffer immediate and irreparable injury if the Commissioner and Department of Family and Protective Services are allowed to continue to implement and enforce this new department rule that equates gender-affirming care with child abuse. Soifer said at the conclusion of the hearing. Again, it was for care, and that was the issue. But okay. Soifer's decision comes after the Texas Supreme Court issued a mixed ruling last month, allowing the state to investigate parents of transgender youth for children's abuse while also ruling in favor of one family that was contacted by child welfare officers following Republican Governor Greg Abbott's February order. Abbott had ordered state welfare officers to investigate reports of transgender children receiving gender-affirming treatment. By the way, when we're done with this, we have to have a bit of fun at Nick Ricada's expense because someone's got to explain to me a whole bunch of things, okay? Anyways. Friday's ruling was in response to a challenge from Lambda Legal and American Civil Liberties Union on behalf of the families of 3 teenagers and PFLAG. 2 of the teenagers were 16 and 1 was 14, which seems like it might be a problem if you're trying to make decisions that might have permanent life impacts, but that's just me. A Lambda Legal attorney told the judge the 14-year-old's family had found out after the lawsuit was filed the state investigation into them had been dropped. The family said in court filings the investigation had prompted anxiety for them and their children. Maybe less with the, conversion stuff, but that's, again, just me. The mother of one of the teenagers said in her child's attempted self-harm and was hospitalized the next day. Abbott issued his order. The day he issued the order. Wow. The outpatient psychiatric facility the child was reported the family for abuse after discussing hormone therapy had been prescribed, the mother said in court filing. Not for nothing, but there was a 14-year-old who apparently tried to do the self-deletion thing the day the governor issued his order. Did the 14-year-old know about that? I don't know how many 14-year-olds are keeping their ear to the ground over executive orders, but okay. All right. There's that. In March, a district judge issued a temporary restraining order following a lawsuit on behalf of a 16-year-old whose family claimed to be under investigation. The Texas Supreme Court ruled in May that the lower court overstepped its authority by blocking all investigations going forward, but they're still trying anyway. The Texas Department of Family and Protective Services has said it opened 9 investigations after Abbott's order, and an earlier non-binding legal opinion by Attorney General Ken Paxton labeling certain general conforming medical treatments, those would be the key words, the medical treatments, as child abuse. That was the problem. Or the concern, the medical treatments. Those were the things the government was concerned about. Yeah, let's wrap that up. My tolerance for annoying is really, really low today. I just want to say, today is not a day you necessarily want to test Uncivil, because Uncivil is annoyed. Thus, that brings us to the end of the discussion about the latest ongoings as it relates to this Texas executive order. So a judge has issued a restraining order against 3 families, or I guess in favor of 3 families rather, who were being investigated. But the Texas Supreme Court has said that the lower courts don't have authority to block all the orders, but it seems like they're trying to anyway. So there's that thing. So I'm sure this will continue to be litigated over as things go on, but that, for at least the moment, brings this end of discussion of this case. We've done Jackbox on this channel before. If you guys are good, we could do some Jackbox after. If we get up to 90, let's do this. If we get up to 96,000 subscribers before the end of the stream, we'll do some Jackbox games. How about that? That'll be fun. We'll do at least 2 rounds of games. That'll be fun. All right. Let's do another one. Okay. Anthema says Kurt, ... Weren't I over 96 recently? Yes, I did. I lost some subscribers because I had we discussed this with the technical issues from republishing. Because of the YouTube problems we discussed before, I did a video about it. But basically, when I did that, and I knew it would happen because it happened last time, basically a lot of my subscribers got flooded with notifications, and a lot of them turned off notifications because they couldn't understand why they were being flooded with notifications for videos that were months old. So I lost like 500 subscribers like instantly, and I knew it would happen. It was just unavoidable. So we have to rebuild a little bit. Legal Bytes' camera doesn't have a narrow field. Well, we're at f3.5 right now. I tried even 8 and I was having problems getting it in focus. Well, we can try some more. Yeah, so we lost like 500 subs instantly. So that's what happened. All right. Possible nullification of the reading of Miranda rights by the Supremes. What do you mean? That box I got on sale for like $140. It's still way overpriced. Especially if I can't get it in focus. If I can't get effects in focus, I'll just return it. It's way too much money. If it's not going to be in focus, then I'm definitely not going to use it. Yeah, I'm not worried about getting them back. Just thought it set a goal, if we could get it, why not? All right, let's cover this case. For today's case, we cover a recent settlement award that was upheld that caused Skyco to pay... Wait, how much was it? It was $5 million, wasn't it? Yep. Okay. I just had to double check because it didn't sound right in my head. It was right. For today's coverage, we are discussing a situation in which a woman contracted an STD by having certain intimate affairs in the back of a car. The car was insured by Geico, and recently she was awarded a settlement of $5.2 million. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we're talking about getting busy in the backseat and Geico paying for it. This is the case of Mo versus Geico. In this case, Mo decided to have some relationships in a car. Mo got STDs from someone having sex in the car. The car, of course, was insured by Geico, so Geico had to pay out for the injury to the tune of $5.2 million. How'd this come about? Well, that's what we're here to discuss. Let's get started with this. Geico appeals the judgment of the Circuit Court of Jackson County, confirming an arbitrator's award against Geico. After Mo contracted anogenital human papillomavirus, HPV, she submitted a settlement offer to Geico, asserting insured negligently infected her with the disease during encounters in the automobile, and insured's Geico insured automobile provided coverage for injury and loss. Geico denied the coverage and rejected the settlement offer. So yes, she got the HPV, she says, from a tryst in the back of a Geico insured car, and therefore Geico needs to pay for the injury. How exciting. The insured and Mo entered into an agreement pursuant to law and agreed to arbitrate. The arbitrator found the insured negligently infected Mo with HPV and awarded $5.2 million in damages. Thereafter, Mo filed this action with the trial court. Geico moved to intervene and moved to confirm the arbitration. The trial court granted the motions and entered judgment. So therefore, they arbitrated the case, and the arbitrator said, yes, you got the STD from the relationship in the back of the car. The car is insured by Geico. That is a loss that occurred to you in an insured automobile. So Geico has to pay for that loss. How exciting. I didn't know this was an option, but apparently it is. The arbitrator determined that there was prurient activity in the automobile in either November or December of 2017, which occurred in Jackson County, Missouri. The activity in the vehicle directly caused or directly contributed to the Mo being infected with the HPV. Insured knew that he'd been told his throat cancer tumor was diagnosed as HP positive. Okay, so he has throat cancer. That's HPV. Okay. Insured should have disclosed the diagnosis to Mo prior to the activity, but did not. Insured was negligent and liable for Mo contracting HPV. The arbitrator found the amount that would fairly and justly compensate Mo for all the injuries is $5.2 million and entered an award of that amount. Wow. As with any court-tried case, we will affirm a trial court's order confirming arbitration unless it is unsupported by substantial evidence, is against the weight of the evidence, or erroneously declares or applies the law. So yes, one of the big things to note here is that this is a result of an arbitration proceeding, not a court proceeding, because, Geico, as part of its policies, pretty much like everyone business ever says, hey, you've got to arbitrate these things rather than bring them in a court of law. Now, that comes with advantages and disadvantages for both parties. But one of the biggest problems, or biggest aspects, I suppose, to arbitration is once the arbitrator rules on something, it's basically borderline impossible to get that to be overturned. Because the Federal Arbitration Act specifically allows for arbitration. So unless you can show some basically erroneous law by the arbitrator, it's basically borderline impossible. So you can't, and the arbitrator gets incredible amounts of discretion, even more so than a district judge, depending on the nature of the arbitration and the rules of the arbiter. So like what evidence comes in and doesn't, and what testimony comes in and doesn't, I mean, the rules of evidence as you know them and love them don't necessarily apply in arbitration. It's a matter of private contract. So the rules are whatever the arbitration association says they are, which is a practical matter, tends to give the arbitrator a lot of ground. Now, typically the businesses like this because arbitrators tend to rule for the repeat customers, like the businesses. But, not so much. And now they're being ruled against and they'd like to appeal. Yeah, not so much. No. Yeah, you're bound by the decision. In case you want to know what an arbitrator looks like, think Judge Judy. Judge Judy is an arbitrator. That's what she is. She is not a recognized court of law. She's an arbitrator. She is a private arbitrator, privately resolving disputes between the parties. And they are subject to rules by the arbitration that they agreed on, Judge Judy. So when she makes judgments, she has the force of laws that reflects those individual parties. And so, this is just Judge Judy on steroids. But yeah, that's, although it tends to be a little bit more formalized than Judge Judy, but still the rules are kind of up in the game. Let's read more about this. Contrary to claim, Geico was not entitled to develop facts and arguments before judgment. This is what I'm talking about. Geico's ability to offer things at trial are significantly reduced because it's not a trial, it's an arbitration. So rather the relevant proceeding in the arbitration agreement simply gives the insurer the right to written notice and an opportunity to intervene and provides no other rights beyond what any other intervener would. It's well established an interviewer must accept the action pending as he finds at the time of invitation. At the time of the intervention, liability and damages have been determined by an arbitrator and confirmed by the court. Geico, therefore, has no right to litigate these issues. So, Geico was basically squeezed out completely from the arbitration proceeding. It was a proceeding between the person injured and the injuring party. Geico, the insured, was basically completely excluded, totally. And so, that sucks, but that's the nature of the agreement you wanted. Geico argues the intervention under the relevant rule provides substantive rights to interveners, including the right to raise legitimate defenses and assert their rights against claims alleged in the suit. We do not deny that an intervener, whether intervention is permitted under the relevant rules, enjoys the same right as any other party in a lawsuit. However, we return to the maxim that an intervener must accept the action pending as he finds it at the time of intervention. So Geico didn't have the right to intervene until the judgment had already occurred, by which point it's kind of too late. But that's what you wanted because that's the nature of the arbitration agreement you asked for, so yeah. As described above, when Geico intervened, liability and damages had already been determined. The rule does not bestow Geico the right to relitigate those issues. Yep, not so much. Try better next time with your, you wanted it this way, incidentally, because normally you are the one in arbitration and you don't want the other party relitigating the issues at the district court, right? You don't want the other party has a right to intervene, but you don't want them being able to offer issues. So you wrote this thing because normally you have the right to participate and you don't want the other guy intervening. Well, now it's being used against you. So that's just too bad. Okay. Geico also asserts the trial court erred by confirming the arbitration award because the state and federal constitution provide a party with the right to define its interests, and Geico was denied the right to litigate its interests before judgment was entered against its insured. Too bad, so sad. Specifically, Geico asserts that confirming the application violated Geico's due process rights under the Constitution, and the trial court judgment violated their constitutional rights of access to the courts. Geico's claim of constitutional deprivations presumes Geico was denied the opportunity to defend its interests relating to MO's claims against the insured, including the ability to challenge liability and damages. But Geico did have the ability to participate and defend those interests, including the ability to challenge liability and damages by entering a defense of insured. Geico did not take advantage of this opportunity and instead denied coverage and refused to defend insured. So one of the things that happened here is that Geico wasn't allowed to the party because initially it denied coverage. So it said, oh, we're not involved in this, right? We're not involved in this thing. So we're denying coverage, so we're not involved. If they had offered a defense instead, right, if they said, okay, we're involved in this, but, we're not going to cover it because of reasons under the contract, that would have been different. But basically, Geico screwed this up because it waived its own rights, is basically the long and short of it. The court is saying, hey, Geico, you had the opportunity to be a party here. You could have insured them. Or you could have said, okay, we are taking on this and we want to fight it in that way as a party. But they said, nope, not us. We're not involved at all. Not us. Don't look to us. We're not going to insure this, right? So they're out. So now the one party has to sue the other party in arbitration. And they said, oh, wait a second. No, they are insured. Oh, wait. No, because now, see, the trial court found the relevant facts. And that now triggers your policy. But you didn't want to participate. So see, this is where Geico screwed up. And now they're trying to come in on the back end. Funny joke. Trying to come in on the back end and trying to say, oh, we want to try it now that we weren't participating in the first place. Yeah, no, you can't really do that. That doesn't really work at all. No. I was on the live stream for quite a lot of the live stream today with Legal Bites, yes. I was on for several hours, as a matter of fact, today, yes. Accordingly, we find the timing of the trial court's judgment confirming the arbitration award did not violate Geico's constitutional rights to due process or access to the courts. Thus, the judgment is affirmed. So that brings us to the end of this case from the Minnesota Court of Appeals dealing with Geico. Geico has to pay $5.2 million in damages because of a whole bunch of confluence of factors. First of all, they wanted their contracts to be arbitrated, and then they didn't want to play in the arbitration because they didn't think they were responsible. So they let the parties fend themselves. And the court said, well, the arbitrator, more to the point, said, yeah, no, the one guy harmed you. But also that, yeah, you're insured. Wait, that's not fair. Sorry. So now you have to indemnify him because it's part of your contract. Wait, no, we shouldn't have to do that. Well, you should have participated. We have the right to participate now. No, you really don't. So yeah, Geico has to pay $5.2 million for a little backseat roll in the hay. At least from the moment, that brings us to the end of the discussion of this case. Someone asks, what is the reason for the long pauses? Well, it depends why I'm long pausing. Sometimes it's because I'm reading. Sometimes it's because I'm reading and I want to figure out what I'm going to talk about next. All right, I'm reading. I'm like, okay, what do I want to talk about next in this case? Where do I want to go next? Because the whole thing is like, well, how long was this thing? It was 15 pages. And we cut that down quite a lot by focusing on issues I thought were important because it's my channel. So yeah, the long pauses are because, or it was because in this case, or it was because I got a text message, and the text message I was reading on my phone was very, very concerning, and I wanted to read it and think about it for a second. There's a reason why. Sometimes the real world interrupts. Okay, let us do this, and then we're going to do something from Nick Ricada, because I want to talk about this, because I think it's funny in terms of how people perceive me versus perceive Nick. So, part of my continuing interesting things. Okay. Let's try again. There we go. Do I have any info on what YouTube is doing to screw over my channel? Not in particular. Not in particular. Why would I? For today's story, we cover the latest in Toddy Westbrook's legal troubles as new lawsuits get filed in Nevada. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we're covering a new lawsuit involving Toddy Westbrook. Toddy Westbrook has been a time-to-time feature of the channel. We got our start being exposed to the world of Toddy Westbrook through the world of Katie Joy Paulson, who we've also talked a lot about on this channel. Toddy Westbrook is a beauty influencer and has a YouTube channel that's very, very popular and with many, many millions of subscribers. And she has beauty lines and so forth and so on. Unfortunately, she's had some difficulty in her business relationships as it relates to her business partners through a whole bunch of problems. And now we have the latest and possibly greatest in Nevada, which is the home of the corporate form. So we will read this and see what is going on. Let's get started with this. Also, Stephanie told me that I should do this live and live react to it because I'll lose my shit and that will be funny. So I guess we'll find out. I could use the pick-me-up. In or about November 2020, Mr. Swanson, the business partner, called a childhood friend of Miss Westbrook. During the phone call, Mr. Swanson disparaged Mr. Westbrook by telling the friend that Mr. Westbrook had removed his mother from life support to steal his sister's inheritance, and that Miss Westbrook should be worried for her safety. Yeah, I mean we've heard this before via Katie Joy Paulson. So yeah, okay. Let's carry on. During the same phone call, Swanson threatened that he had an embarrassing recording of Westbrook that he would release publicly to ruin her reputation and career if she did not contact him immediately to settle a lawsuit then pending in California. Danger, Will Robinson. Sounds like that might be extortion and blackmail. Let's read some more. Swanson told the friend to pass the threatening message along to Westbrook, and that Westbrook must take action to resolve the California lawsuit or he would ruin her. Sounds more like the blackmail. Swanson further informed the friend they'd also reached out to members of Westbrook's family to warn them he had an embarrassing recording he intended to use to ruin Westbrook if she did not settle the California lawsuit. More with the blackmail and extortion. Okay, possibly, allegedly. Upon information belief, the recording that Swanson referred to in the phone call and that was being used to extort the Westbrooks is an illegal, secret audio recording that Swanson took of a confidential business meeting that occurred in Swanson's home in California between the Westbrooks and Swansons. California is a two-party consent state, so they both need to know the recording is happening for it to be legal. The Westbrooks had no knowledge that the audio recording of their communication was taken, and they did not consent. That would be what would make it illegal in California. Not all states, mind you. Many states are one-party consent. Not California. From the time the Westbrooks learned that Swanson had made the illegal recording and could learn, Swanson had been continuously absent from the state of California, thus tolling any statute of limitations pursuant to California law. So they're trying to say that they're within the statute of limitations because he had absconded from the jurisdiction. technical argument. We'll deal with it later, I'm sure. As a direct proximate result of the conduct, including illegal recordings and attempted extortion, the Westbrooks have suffered financial damages and severe emotional distress. Okay, so let's try what we got. Invasion of privacy under California law. Because Swanson's recording was made in California, California law applies to the legality in effect. Sounds right. California law provides the legislature hereby declares that the advances of science and technology have led to the development of new devices and techniques for the purpose of eavesdropping upon private communications, and the invasion of privacy resulting from the continual and increasing use of such devices and techniques has created a serious threat to the free exercise of personal liberties and cannot be tolerated in a free and civilized society. The legislature by this chapter intends to protect the right of privacy of the people in the state. Fine. The California law prohibits a person from recording a confidential communication without consent of all parties, which we often call two-party, because normally there are two parties, but of course all parties is more proper. A conversation is confidential if a party to that conversation has an objectively reasonable expectation the conversation is not being overheard or recorded. So this would, for example, preclude any situation in which the recording would be obvious or otherwise noticed by appropriate signage or something like that. Mr. Swanson surreptitiously recording a private business meeting between the Westbrooks and him that took place at the home in California. The meeting was a confidential business meeting, and Westbrooks had an expectation of privacy as to communications during their meeting. Yeah, they had an objectively reasonable expectation the conversation was not being recorded. If it's in someone's home, that would seem to do the trick, yes. The Westbrooks have no knowledge of and did not consent to the recording of their communication during the meeting. The illegal secret recording of the private business communications was made for the purpose of harassing the Westbrooks and or to harm Westbrook carefully built brand and reputation. Okay, maybe. Swanson's secret recording of the confidential communications violates the law, and as a result, they're entitled to relief under law, including but not limited to statutory damages and or triple actual damages by enjoining Swanson from releasing the audio recording. The Westbrooks have been forced to hire attorney to pursue this action. Okay, but this is all California, and we're in Nevada. So my first question is, why is this appropriate cause of action here? Because the business, well, hold on. Because it is Toddy Westbrook, the individual, and James Westbrook versus Clark Swanson. Is Clark Swanson... Oh, hold on. Oh, that's why. Clark Swanson is a resident of Nevada. Okay, never mind. Clark Swanson's a resident of Nevada. That will do the trick. So you should be able to get it down there. But the recording happened in California. We might have a fight over venue. I can see a venue fight happening down the line. Well, we'll deal with that later, I'm sure. Right, so let's talk a little bit about what I'm talking about, right? So we've talked about jurisdiction issues before. Jurisdiction is where we can sue the people. We probably have jurisdiction here because he lives here. The Nevada courts have general jurisdiction over him. So this is a proper jurisdiction. But it's not necessarily the only proper jurisdiction. The call apparently occurred in California, which would make the act that occurred in California. So that would be a place appropriate jurisdiction too, in California. So we got two places apparently appropriate jurisdiction. We've got Nevada and we've got California. Now, normally, when you have two different places of appropriate jurisdiction, it's plaintiff's choice. You can pick one or the other. But that isn't necessarily always the rule. And there is an idea about venue, right? So what is the best venue for this? Well, it is California law. It's California's courts, California's statutes, California's everything, right? The recording happened in California. So, you know, the home was in California. So maybe California is a more appropriate venue. But of course, then the only way this comes up is for Swanson to ask for venue to be changed. Which, why would he? He has the home field advantage. So there's really no reason for him to. The only other thing he could do is bounce this up to federal court, I guess, if he wants to, which might make sense. But because as long as, well, we'll have to see where it is in the call of relief, because we got a diverse party. As long as we're asking for more than $75,000 in damages, which I imagine we are, then the defendant could bounce this up to federal court. They call it removing it to federal court, is a technical name for it. I'm not sure why they call it removing, but they do. So he could remove this to federal court, potentially. He could also say it's his improper venue and move it to California, but why? That's more inconvenient for him. So it's not an issue unless he brings it up, but worth noting anyway. Let's carry on. Oh, California already said you don't go here? Okay, that'll do the trick too. That'll do it. Fair enough. Which wouldn't make sense for him to then relitigate and say, I want it in California, because he'd be collaterally stopped. So yeah. So someone in chat said that they've already had this fight in California, and they said it's an improper place here. Okay. Fair enough. So that means that the only reason that would be true is because Swanson himself asked for that. So the courts agreed with him. Nevada, of course, is bound by that judgment, full faith and credit clause of the Constitution. So they are bound by that determination of California. So now they're in Nevada. Nevada is an appropriate place because he lives there, and he can't now come back and say, no, I want venue in California, because he just said I didn't want it there. So he's collaterally stopped from making that issue. So his only thing left he could do is remove it to federal court, which I think is still an option. But thanks for the no. Appreciate it. See, we learned something positive that we can put in the edit. It's all good stuff. All right. So under the relevant law, the courts of record within their jurisdiction shall have powers, rights, status, and other legal relationships that they would have. Yeah, that's basically the All Writs Act, basically in state law form. There is a present controversy between the Westbrooks and Swanson. Sure. The foregoing substantial controversy is right for determination. Adverse interest. Okay. The recording is made illegally, may not be used in civil proceeding, no right to use to maintain the recording, and the Westbrooks are entitled to relief. Okay, they're forced to hire an attorney for this. All right, so what do we want? Treble statutory damages, award of punitive damages, judgment and award that the recording was made illegally, injunctive relief, and such other relief. Well, they're not asking for an exact dollar figure, and they're not saying, it doesn't seem clearly obvious that it's more than $75,000. So I'm not even sure that they can pump this up to federal court. I mean, they can try, I suppose, but there doesn't seem like there's enough here to remove this. The nice thing you'd like them to say explicitly, we're suing for not less than 75,000. Well, more than 75,000 to be exact. They have to say more than 75,000. Not saying that. They're saying it's triple statutory or triple actual. And then it's like, well, is there any reasonable possibility of this being more than $75,000? No, not really. So I think we might be stuck in state court. So I think we're stuck here. Although they could try to remove it. But yeah, that's what's going on. Pretty interesting stuff. So that brings us to the end of the discussion for the moment, the Toddy Westbrook and James Westbrook versus Clark Swanson thing. We want to exempt this from arbitration because we want equitable extraordinary relief in the form of the injunction. Maybe. Although courts do like the arbitration, so they might want it to go to arbitration first and then issue an injunction, or they might do the injunction and do arbitration. I don't think you're getting out of arbitration all the way considered, because that just doesn't seem like that's going to happen. But you can try. So yeah, that would be the next thing. Either Swanson tries to kick this up to federal court, maybe, although I think he has a problem, or he tries to invoke the Federal Arbitration Act and say this should be arbitrated. And that they're asking for injunctions under relevant law, but the way the Federal Arbitration Act is interpreted, it's interpreted extremely broadly. So I would not be surprised if the Nevada court kicks this over to private arbitration for any sort of award. And then if there's an award, then they can have injunctions afterwards in pursuance of the award. I don't think they'll get in on the front end. They're not going to get out of this completely. They're not going to get an award of damages, I think, from Nevada. That seems unlikely. So I'd imagine we're not long for this world in state court one way or another. But we'll follow it for as long as it does. And that, for the moment, brings us to the end of discussion of this case. Someone said check my Twitter mail. Let's check my Twitter mail. Well, Jacob Grawl said, quit being a simp. Quit feeding off of other LawTuber's success to appease your own financial gains. You clearly have alcohol abuse issues alongside your depression. I really hope you're able to get the help you need. Justice for DUI guy. I think we'll be blocking him. Silver Super, I sent you a content and ID on Instagram. I'll take a look. A spot came up on YouTube. Michelle Dauber and Amber Heard Enough is Enough voter project. Miss Heard is the poster girl for support of a California effort for a marital rape law. Do they not already have one? Is it not already illegal to rape if you're married in California? That'd be surprising if it's true. But thank you very much for your super chats. You worry about my drinking? I don't drink that much on stream. I don't drink as much, nearly as much as Nick Ricada does. Thinking about the name, I already blocked him. I don't even remember the name anymore. All right, so let me show you something from Nick's stream yesterday, because I think it's really interesting in terms of people's perception of me as this misogynist guy, because I just think it's hilarious. I'm just going to have a chat roll that says, mention my drinking and get banned. You don't know me. I really should have a chat roll that says, mention my drinking and get banned. Because you don't know me. You're not in a position to know me. You're certainly not in a position to be act like, even if I had a problem, you're not in a position to intervene about it. So I should have a rule that just says, mention my drinking and get banned. All right, so maybe we'll do that later. All right. Yeah, several streamers address someone from the audience diagnosing them. It is really annoying. Yeah, it's incredibly annoying. So there's something I want to show you yesterday from his stream. Hold on. So let's see. How do I do what I want to do here? Let's do it this way. Stephanie, are you still here? Oh, this is pretty interesting from yesterday. All right, so this is from yesterday's stream. So let's do this. All right, so I want to change this window to this. Okay, and I need to readjust the window so you can see this because I thought it was hilarious. People talk about my misogyny. All right, so let's cover Nick yesterday. Nick is my friend, by the way. I'm not shitting on Nick. I'm more shitting on the people who shit on me, just for the record. All right, so okay, hold on.
It's Florida. Some of these people may just be watching an alligator's asshole.
All right, so here's what the lead into this in case it's not clear. All right, so there's a death penalty case in Florida. The convictions already happened. They're selecting the jury for the death penalty phase. They're having trouble finding the people. The judge has ruled. One of the defense lawyers, who's like an expert in this, apparently has COVID and is not available. The judge has ruled that the jury selection will continue. The lawyer who is ill is welcome to participate via Zoom if they want, but they're not going to delay for the illness. Okay, so that's the issue that's been ruled on. Judge says yes, jury selection is going to continue. This sick lawyer, you guys already have like 8 lawyers or whatever it is, so you can carry on. The one lawyer who isn't here, who's an expert in this apparently, whatever, can participate via Zoom, send notes via email or text message or whatever, right? Okay, so that's the legal ruling. All right, let's go on.
Thinking it's CNN. And who could tell the difference? And if that's the case, they probably haven't seen anything about the Uvalde shooting. Very, very possible you will find surprisingly uninformed juries given enough opportunity. So we'll have to see how that is handled. She hasn't ruled on it yet. Judge Scherer and McNeil heatedly argued Monday over the judge's insistence that jury selection move forward without the presence of Casey Secor, a South Carolina death penalty defense specialist who is assisting McNeil. Scherer said Secor could watch the proceeding on a video link and communicate with McNeil by phone or text message. Scherer accused McNeil of trying to intentionally provide ineffectual counsel to Cruz by saying her team would not participate without Secor. At one point, Scherer recessed the hearing, telling McNeil to consult the Florida bar over what sanctions she might face if she and her team refused to participate. Damn. Shots fired. Should we do this in the shallowest way possible? Let's see who's right.
Okay, so this is where it picks on, right? So you heard the lead on, and then like, okay.
Wait, it's 2 L's. Here we go.
This is why does Uncivil Law get Uncivil Law get accused of being a misogynist portion of the stream? That's what this is.
Oh, hey, this is going to be a tough one. Let me see if I can do this. Oh, wait, it's not as tough as I thought. Her LinkedIn picture was a lie. All right, so here, we'll give me just a second to prepare this contest of champions. And hold on. All right, so we have a champions contest coming here. You guys have to determine which one of these legal Titan ladies is correct. We've got on the left, you'll have Assistant Public Defender Melissa McNeil, and on the right, Judge Elizabeth Scherer. So I don't know who's correct, chat. I'm going to put up a poll. Which lawyer is correct? Defense attorney Melissa McNeil, Judge Elizabeth Scherer. All right. So this is this is scientific legal analysis right here. You have to determine which one of these ladies is the correct one on the on the issue of whether or not they should proceed with jury selection on Monday. That's the question. So, the lady in green on the far left. That's true. That's true. This lady is always correct. But there we go. So I'll leave that to the scientific understanding of the chat. Certainly a bunch of scientists out there who know the answer to these very, very tough questions. Let's see.
All right. So he sets this up. And so this is like, okay, so he sets this up, like which one's right based on the image, based on what they look like. And then he says this, just makes me wonder why people ever accuse me of being a misogynist at all. So hold on. I'm looking for this segment, by the way. It takes a second. This is going to take a second. I think I'm getting close to the finding of what I need to find. Okay, yeah, this is what I want. Okay, hold on. So then he says this as he's closing out the poll, and I want people to say the whole point of this is not to call out Nick. The whole point of this is, why do people call me misogynist and not Nick? Because he says this. Hold on. Oh, I'm sorry. I forgot to unmute the audio. I'm sorry. That was my fault. I forgot to unmute the audio as I was searching for it. I forgot to unmute the audio. Okay, let's go back.
Votes, and the judge overwhelmingly wins. She is more correct. And I think we have our very scientific, and how do I word this? Certainly not misogynistic way of determining who is correct by looking at the women objectively. And by objectively I mean as objects, and determining who is more correct based on physical attractiveness. And that's, I don't know if you guys know this, but there's science to this. That is how you determine if a woman is correct, if she is more attractive, she is more correct. And so there's a scale of correctness that women all have built into them, and it's called their looks. This I told you this is true. Only facts being spit out here. There are certain women who are always correct. There's certain women who are maybe correct 9 out of 10 times. And that's a pretty high rating. Then there's some women who are correct 2 out of 10 times. They tend to be anime voice actresses. For example, hypothetically, 2 out of 10 times, they're correct. Jen Psaki, for example, was correct maybe 3 to 4 out of 10 times. It's completely and entirely based on their attractiveness. That's how all women should be judged all the time. Let's see. Let's check that live subscriber count.
Now, he's obviously kidding. I know he's kidding. You know he's kidding. Everyone knows he's kidding. Everyone knows he's not serious. Everyone gets it. He's making jokes. I get that he's making jokes. I just want to know why I get shit in my chats and on Legal Bites chat about Uncivil Law, the misogynist. when I got this asshole over here. When I got this asshole over here telling jokes way worse than anything I've ever said. That's all I want to know. Why do I get the misogynistic hate? Man. Yeah. You think it's delivery? It could be the delivery. It could be delivery issues of my jokes. That could be the issue. That's true. That could be issue. Because it seems like you're serious. This is fair. This could be the issue. I tend to like to deadpan my jokes. I tend to like to tell my jokes much more deadpan. So this could be true. Maybe this is the issue. He tells his jokes, and it's obvious he's joking, whereas I actually rely on I rely on the intelligence of the listener to understand I'm joking without overtly conveying that I'm joking. I'm depending on this is my problem. This is absolutely my problem. I'm depending on the intelligence of the listener to listen to me without any obvious sign I'm telling a joke, and listen to me and be like, what he's saying is so absurd. It must be a joke. See, the joke is conveyed in the subtlety of the deadpan, right? But then some people are idiots and they don't get the joke. Whereas he's like telegraphing joke. So he's lowest common denominator. That's the problem. He's lowest common denominator, and he is helping the plebes understand the joke, whereas I'm depending on you, the audience, to listen to me and understand it's a joke, not from me like overtly laughing at my own joke, but from me deadpanning it and you realizing it's absurd, and the absurdity carries the funny. This is my problem. This is a fair point. This is a fair point. This is yeah. Okay, I get it. You're right. This is yeah. Okay. Let me read some super chats from you. Mark said, $20. Your humor is simply perfect. Brilliant and knife heads, thank you. You're welcome. Alexandra said, Kurt, I'm curious, and you don't have to go into details, but are you more of an Edmund Burke conservative or Leo Strauss? Although Thomas Paine is probably more comes to mind than either one of them, to be honest. Flying Monk gave some money. Amber Heard's Tur said, I have nothing to contribute to the conversation, only the grift. Jennifer Edwards says, California said you don't go here already for lawsuit. That's why it was filed in Nevada. Cool. $1.99 from Help Your Cat to Drive, which appears to be a lemon flash dancing. Okay, thank you. Myra gave $1.99. It's happy hour somewhere. Ignore them. I do. Hello Beauty promo every time Tony's mentioned. Carlos Estrada said, have you tried Bumblebee Tuna Honey yet? I have not, but it's on the list. And Soren Chris says, Nick clearly doesn't give a shit. Any of you appear to care how people respond. This is also true. Nick is much better at the not giving a shit thing. He's much better at believe. He's much better at not reacting to the haters. But I got haters. I got hater problems. So, yeah. Including, I think, some fellow creators who's, well, my style seems to, not necessarily rub the right way, but that's okay. I mean, we can't all be compatible with each other. All right, I'm going to go fuck with the camera for a while off screen and see if I can deal with whatever this bullshit is so I can make this work. That is now my quest in life. How do I change the depth of field so it will like make it in focus? That is now my quest. Jay Wolfenstein says, given how ridiculous the world is, can you really say something so absurd it has to be a joke? Have you read the comments? This is true. This is also Poe's Law, isn't it? Poe's Law. It's impossible. It is impossible to create a caricature absurd enough that it can't be understood for the genuine article. So this is just Poe's Law, right? It's impossible to state something that someone couldn't actually believe. I'm depending on the intelligence of my audience to overcome Poe's Law. I'm depending on them to understand that despite the fact that it's impossible to tell something so absurd it couldn't be believed, that I'm not actually serious, even though I sound serious. I'm depending on the audience to do quite a lot of lifting with their mind here. But it's funny. Yeah. Make Nick do a get Uncivil to 100K stream. Pog. Reasonable man test. Yeah, there you go. Absolutely. So what else should we do with our time? Stephanie, you're still here? What do you want to do? You want to do some, let's see what Stephanie wants to do. We could do some Jackbox games now. We could do some, whatever. We could do, I don't know, anything. Bar exam questions? I do need to do bar exam questions again pretty soon. I think your problem is trusting people. True. Ask Ishka, member for 6 months. Thanks for hitting the join button. Hey, babe, thanks for streaming. How goes from me to you? Keep on keeping on. Well, thank you. That's very kind. By the way, let me see if I can do this. Can I do this? If I say super chat? No. I don't have the gift membership thing yet. I signed up for it. Nick has it for beta, but I don't have it yet. Dig into Durham. I need to do a recording on, I was meant to do it today and I never got around to it because of the charity stream. I need to do a recording tomorrow on Daybell and on, excuse me, and the other thing. Get a sidekick, your channel's sadly gone stagnant. I don't think I need a sidekick for that. I mean, everyone has growing pains. Nick was stuck at like 198 forever. Before Rittenhouse, Nick was stuck at like 195, 198 forever. Rittenhouse really got him over that huge, but like Nick was stuck for a long time. And I don't think I'm stuck. I just lost some subs because of the recent kerfuffle technically. 100K when the abortion 2A cases out, maybe. I hope Johnny doesn't say no to the money he's awarded. He needs the leverage. He can donate all to charity once he gets it, which would be hilarious. Eye candy? Did we lose Stephanie along the way? Excuse me. And the Daybell thing will be a huge hit for the channel, yeah. I think that'll be a huge hit for the channel. Contrarian420 says, why would Nick help you to hit 100K when you just accused him of misogyny to make yourself look comparatively better? Well, if what you heard me say was me accusing Nick of misogyny, you have listening comprehension problems. You should probably go see my listening comprehension video. I didn't accuse Nick of misogyny. Listen harder. Christ. This is why I can't trust my audience, because they can't listen. People are not listening. I know. People are not listening. Am I still working as a lawyer? Until July the 2nd, I am. I've given my notice and I'm waiting for the clock to run out. Basically, I'm closing up shop, closing out cases. So I'm on a light because I'm not taking in new work. I'm just closing out work, so it's kind of light. So I'll be doing fine. Listen to respond rather than listen to understand could be. Yeah. Am I sad to finish? I'm scared, but I'm not sad. I mean, I'm giving up a lot of money. But that being said, I have been increasingly unsatisfied for several years at this point. And it's time to go. This YouTube thing will give me enough money to like not starve to death. And I'm going to take the Texas bar and just give the YouTube thing my all for 6 months. So from July 2nd till what would 6 months later be? Like February 2nd? So basically through the Daybell trial, basically. And reevaluate. And I can go back. Yeah, I could go back. I just have to go back to a different employer, which is fine. On the patent side, I should have no problem finding work in Austin as a patent lawyer. You know, so. Why am I sad? I'm not particularly I'm sad. I'm not really sad. I was frustrated because I was having technological issues. I'm scared because I'm giving up my job and I'm giving up a huge amount of money. So that's scary. And I want the child to succeed. So there's that. Why did I move to Texas? Better climate, better weather. Was my family? My family's very supportive about it. My family's very supportive. I live in Austin, Texas right now. Better weather. Better weather, sunnier, clear skies. No income tax is nice. Doesn't hurt. Yeah, Dell, Intel, Google, IBM, Qualcomm. Yeah, exactly. Have I thought about moving the chair back? Well, I'd have to readjust. Well, I'd have to move the entire table back. I guess I could do that. If I sat here, like this, if I sat like way back here, I can make the, so you see more of my chest. I don't know if that's better or not. To be honest. I feel like weird. I never lived in California, All right, I'm going to sign off for now. We'll find another time to do some Jackbox games. I'm going to play with the camera some. I'll get back to you guys. Talk to you later. Bye for now.